Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers 911 calls, the emergency aid doctrine, and private exigent circumstances, and is brought to us by Brian B's channel. Be sure to check out the description below and give them the credit that they deserve. On December 19th, 2020, Officer Macmillan and Officer Hibbets of the North Brunswick Police Department responded to a 911 hang-up call that allegedly originated from the home of an individual who has only identified himself as Brian B. The officers knocked on Mr. B's door and began to question him regarding the call, while Mr. B recorded the interaction through the screen door.
Can I help you? Can I help you?
Yeah. Everything all right?
Everything's
Yeah,
fine.
911 call.
From here?
Yeah. Are you the only one home?
No.
Who else is home with you?
My girlfriend and my roommate.
All right.
Everybody's fine.
All right. Well,
Nobody
apparently
called.
Somebody called and they said it came back to this address, and it said they told us there was yelling or something in the background initially. Then they hung up and they haven't been able to get in touch with everyone since. So that's why we're here.
Nobody called. Everybody's fine.
All right. Can we talk to them real quick?
No.
No, we need to.
Well, you're not.
We need to.
It's not going to happen.
You're not understanding how this works. We got a 911 call from this address.
Nobody called 911.
How do I know that?
Bro, do I have to prove something to you right now?
Yes. We have to speak with everyone who lives here to make sure they didn't call 911.
The officers state that they need to speak with everyone who lives with Mr. B in order to confirm that they did not call 911. In general, the Fifth Amendment privilege against self-incrimination protects individuals against compelled speech to police officers, and only judges have the authority to order an individual to answer a question. This means that Mr. B and the individuals in his home have a constitutional right to remain silent and do not have to answer any questions from police officers, even if they are responding to a 911 call. However, a court would likely find that the officers were within their authority to confirm that the other members of the household were not responsible for the 911 call, and that the officers were not required to take Mr. B at his word. According to Section 2.64.020 of the New Brunswick Municipal Code, the police department has both the power and the duty to protect life and property, prevent crime, and detect and arrest offenders against the penal laws and ordinances effective within the city. Similarly, in the 2012 case of State versus Edmonds, the Supreme Court of New Jersey concluded that police officers were empowered and duty-bound to enter an apartment to check on a resident when responding to a 911 call reporting a domestic violence issue. Even though the alleged victim of the incident, who met the officers outside her apartment, did not exhibit any injuries and denied that there was any problem, the court held that, quote, the officers were not required to give uncritical acceptance to her denials, or honor her objections that they not enter her home, given that her 11-year-old son was inside and might be endangered. The police had a duty to look behind the denials by Ms. Richardson while her son remained potentially in jeopardy in the apartment. Therefore, although the other individuals in Mr. B's residence could not be forced to speak to the police, as we will discuss later in this episode, a court would likely conclude that the officers could enter the residence to check on their well-being.
As soon as we speak with everyone, we confirm everything's fine, we leave. That's it, man. We just make sure everything's fine.
What's your name and badge number?
Macmillan 182.
Name and badge number.
Gary right there. 189 Hibbets.
Right there? Is that what you told me?
Why are you giving us such a problem?
Well, because you're over here shining a flashlight in my apartment. You're over here shining a flashlight. Let me finish what I was saying. Into my apartment. I'm in here taking care of Christmas gifts, watching the UFC fight. You guys come over here banging like a bunch of animals. No one called 911, and you're giving me a hard time. You're still shining a flashlight at me. Turn your flashlight off. Turn your flashlight off.
You're not understanding how this works, man.
Have a nice night, guys.
No.
They said there was a 911 from whose cell phone? What cell phone number? Do y'all have it on record or file or anything?
732-940-76.
94076.
Not my number.
When they call 911.
Whose number is that?
It's not mine.
732-40.
Mine's is 848-466.
No one's phone number here.
All right, well, let's get this sorted out then, so we don't have to come back. All right?
What do you want to sort out? What have we not sorted out?
We sort it. It's a landline, okay?
Okay, no, there's no landline here.
But there's still one registered to this house.
So what do you want me to do for you?
So there, we solved with the 911.
Okay, so get the out now.
Sir.
No, sir. You just slammed the door at me. Get the out of the house.
You don't close the door on the police.
I don't give a You have no right to enter.
We do actually.
No, you don't.
do.
It's a warrantless entrance, so get the out.
Mr. B tries to end the conversation, but the officers do not allow him to close his door, forcing their way into his apartment instead. While warrantless entries by police such as this are presumed to be an unreasonable search under the Fourth Amendment, as the Supreme Court explained in the 2011 case of Kentucky versus King, this presumption may be overcome in some circumstances, including, quote, when the exigencies of the situation make the needs of law enforcement so compelling that a warrantless search is objectively reasonable under the Fourth Amendment. The court then went on to describe several categories of exigent circumstances where warrantless entry to a residence was reasonable, including the emergency aid exception, which allows officers to, quote, enter a home without a warrant to render emergency assistance to an injured occupant or to protect an occupant from imminent injury. Some courts that have reviewed the issue have determined that a 911 hang-up and an unanswered return call from the emergency dispatcher is sufficient to allow officers to enter a home without a warrant under the emergency aid exception, while other courts disagree. However, in the 2004 case of State versus Frankel, the New Jersey Supreme Court adopted a totality of the circumstances standard to determine whether a 911 hang-up call allows officers to enter a home without a warrant, explaining that, quote, the emergency aid doctrine only requires that public safety officials possess an objectively reasonable basis to believe, not certitude, that there is a danger and need for prompt action. The police officer at the door, of course, cannot know what type of emergency, if any, lies inside. All he knows is that the caller has dialed an emergency response number. In light of the presumptive emergency, we cannot conclude that the officer is bound to ignore the warning and walk away. The court also concluded that, quote, a 911 call is tantamount to a distress call, even when there is no verbal communication over the telephone to describe the nature of the emergency. The responding police officer is not required to accept blindly the explanation for the 911 call offered by the resident answering the door, but must base his decision on the totality of the circumstances. Given the direct New Jersey precedent on this issue, it is likely that a court would uphold the constitutionality of the officer's decision to force entry into Mr. B's home. Nonetheless, if a similar incident were to occur in a different jurisdiction, a court could reach the opposite conclusion.
Get out.
What's your name?
Get out. I'm not giving you nothing. Get out.
We need your name.
Yeah, you're not going to get it. Get out. Have I committed a crime? Am I suspected of committing a crime? I have a Fourth Amendment right, bro. Don't trample my rights. You're not going to get ID.
You do have a right.
Let's go.
We need your name so you can.
Not going to get it.
You want us to record that we were out here? What happened?
Not
right?
going to get it.
Okay, so when they call 911 again, you want them to come knocking on your door again. I want to record that we came here, we spoke with you, we confirmed that everyone in the house.
Not gonna
that
get
there's
it.
Nobody's number.
Not gonna give it.
That is no longer associated with
Not
this
going
address.
to give you my information because of what you did with the door. Take your pompous, both of you, get the out of the house.
Once the officers become aware that the 911 call originated from a landline and that there are no landlines at Mr. B's address, they ask Mr. B for his name to document the situation, but Mr. B refuses and demands that the officers leave his residence. New Jersey does not have a stop and identify statute that would require Mr. B to identify himself under any circumstances, so he was not under any legal obligation to provide the officers with his name or identification. Additionally, he was likely within his rights to ask the officers to leave his property, as the potential emergency circumstances that justified the initial entry into the home no longer existed. In the Edmonds case that we discussed earlier in this episode, the court stated that, quote, when the exigency that justifies immediate action dissipates, the rationale for searching without a warrant is no longer present. Other courts around the country have reached similar conclusions about the limitations of the exigent circumstances exception to the warrant requirement. For example, in the 2006 case of U.S. versus Lawrence, the District Court for Minnesota held that, quote, although the public safety exception to the warrant requirement permitted the officers to enter the home for the limited purpose of checking on the safety of those in the home, the exigent circumstances that allowed the officers to enter the home ceased to exist once the officers verified that there was no one else in the home, injured or hiding. Similarly, in the 2006 case of Higdon versus Wells County Sheriff's Office, the Northern District of Indiana held that, although officers were initially justified in entering a home under the exigent circumstances doctrine, quote, once officers secured the home and located all the persons therein capable of destroying evidence, the exigency ceased to exist, and they were required to wait for a warrant to continue their search. Accordingly, a court could conclude that the exigent circumstances that allowed the officers to enter Mr. B's residence no longer existed once they determined that the call did not come from that location, and that the officers' continued presence in Mr. B's home violated the Fourth Amendment.
That's it. You me the f- off and you tried trampling in here. You banging on the door like a bunch of animals. Came in here trying to throw your fictitious authority around, walking into my house without a warrant. Get the out, both of you.
We need your name, sir.
I'm not giving you nothing. Get out. I'm not answering any questions. Please get out of my house.
You understand why we're here, right?
I don't care why you're here. Get the out. Turn that off.
So
Turn that light off.
Let me explain this to you.
Jesus Christ. There you go. You see. How many of you does it take to see? What do you want to look
Can I
at?
explain something to you?
I don't want to hear what you have to
You have
say.
people you care about,
I don't
right?
care. Please exit my house.
You have people you care
Please
about?
exit my house.
Sir. All right.
Can they shut the door? Get him out of my
You're not
house?
gonna shut the door with me again.
Well,
Okay,
I
so-
got nothing to say to you.
This is my boss, sir.
Keep him away from me.
What's going on?
I don't want you touching me,
We don't
dude.
know what's going on, sir.
Yeah, this is all.
That's why-
You're just
Hey, man,
sitting
just
here,
to-
got a bang on the door.
I have an internal affairs complaint on one of the sergeants, and now this happens. This is retaliatory. This is another one going to internal affairs. I'm telling you. You guys don't know how to quit. Any of you.
Can I explain to you what's going on?
I want you guys to leave. I don't
Can I explain
care.
it to you what's
They
going
don't
on?
care.
Technically, what you did could have been obstruction. They're here on a lawful police investigation.
Then take me for
You gotta
it.
shut the
I
door.
want you to take me for it.
I didn't observe it, but from what they're telling me, I'm just telling you technically it is. Okay.
Then let's go. I'll take it to court. I'm not. You. None of you are gonna scare me and bully me. None of you. You guys try it all the time. It's not gonna work. What do you have to say that's gonna justify any of this? I want to hear it.
We came out here to investigate a 911 hang-up.
Okay. Did anybody call? Have you figured that out?
No, we haven't.
Okay. So what do you have to figure out? What do you have to figure out?
If anybody was in need of assistance, man.
No.
Does anybody need assistance?
I have
fine.
zero need for assistance.
Perfect.
I'm trying to go back and finish watching this
In
movie.
fact,
All right.
I'm
So can you please?
Yeah.
Please. Okay. Please go.
Perfect.
Have a good day. Take care.
After Mr. B ordered the officers to leave his property, more officers began to appear on the scene, until a total of 9 officers were inside the residence or on the doorstep. Eventually, the officers did leave, but according to Mr. B, he received an obstruction ticket in the mail that required Mr. B to pay attorney fees, fines, and court costs. Although it is unclear whether Mr. B plans to pursue legal action regarding the incident, he has created a GoFundMe campaign to fund his legal expenses regarding the criminal charge. Overall, the North Brunswick officers get a C-, because although they were likely within their authority to enter and make contact with the other residents of Mr. B's home, they also unnecessarily compelled Mr. B to provide his identifying information and remained inside Mr. B's residence well after the exigency and reasonableness of their suspicions were dispelled. One of the officers claims that they need to get Mr. B's information in case another 911 call is made from the same number. However, Mr. B was under no legal obligation to provide his identifying information. Given the fact that the officers were well aware that the 911 call did not originate from Mr. B's address, it is difficult to understand why they couldn't document that information with the address alone. If the officers had received another 911 call from the phone number, they now had enough information to conclude that it did not originate from Mr. B's address without needing his identifying information. The officers' refusal to leave Mr. B's residence after they had concluded that no crime had occurred was nothing short of unprofessional and irresponsible, and it appears as though their reluctance to leave was driven by their insistence on drafting a police report about the incident. Citizens are under no legal obligation to ensure that department policy is fulfilled in the course of an officer's duty, and it is extremely difficult to rationalize the notion that filling out a police report was more important than preserving Mr. B's Fourth Amendment protections. Citizens should never be presented with consequences for not aiding officers in completing their departmental requirements. This is yet another interaction that highlights the unsavory results of equating departmental policy to legal obligations, and officers and departments would do well in recognizing that fulfilling the bureaucratic requirements of their policies is not the sole priority of law enforcement. Mr. B gets a B, because although his hostile demeanor was somewhat justified by the North Brunswick's officers' refusal to leave his property, he made a concerted effort to block their entry when the officers likely had a legal basis for entering, displayed a fundamental misunderstanding of reasonable suspicion in exigent circumstances, and failed to invoke his right to remain silent. There is no doubt that a majority of Mr. B's hostility was driven by the officers' conduct, and it is relatively clear that this interaction could have been resolved more peacefully if the officers officers had vacated the scene in a timely manner. There is certainly an argument to be made that the officers violated Mr. B's Fourth Amendment rights by remaining on the property without a legitimate basis for doing so, and Mr. B was well within his rights to order the officers to leave his home. All that said, the New Jersey Supreme Court has directly ruled that officers do not need absolute certainty that imminent danger exists in order to enter a property, and Mr. B's initial denial of entry would likely be frowned upon by a New Jersey court. Almost anyone would likely have a hostile reaction to members of law enforcement who refuse to leave private property after discovering that no criminal activity was afoot. But it is extremely important to bear in mind how your words and actions will reflect to a judge or jury of peers if the case reaches a courtroom. Invoking the right to silence is not only a powerful tool because of the legal protections that the Fifth Amendment offers, but it can also shield an individual from any personal bias that may arise from the individuals participating within that system. While I do commend Mr. B for having the courage and conviction to remove the officers from his property, I would also implore him to take advantage of every constitutional protection that he is entitled to, such as remaining silent. Be sure to give your support to Brian B's channel. You can find a link in the description below. Let us know if there's an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.